Recognition.
Madam Speaker, I move to suspend the rules and pass H.R. 7072, the NDO Fairness Act, as amended.
The clerk will report the title of the bill.
H.R. 7072, a bill to amend Title 18 United States Code to modify delayed notice requirements and for other purposes.
Pursuant to the rule, the gentleman from Rhode Island, Mr. Cicilline, and the gentleman from Ohio, Mr. Jordan, each will control 20 minutes. The chair recognizes the gentleman from Rhode Island.
Madam Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material in H.R. 7072.
Without objection.
Madam Speaker, I yield myself such time as I may consume.
Gentleman is recognized.
Madam Speaker, as a proud co-sponsor, I rise in strong support of H.R. 7072, the NDO Fairness Act, crucial bipartisan surveillance reform legislation that recently passed out of the Judiciary Committee on a voice vote. This legislation would establish important guardrails for when the government seeks to access someone's electronic communications without that person's knowledge. Under current law, after the government obtains a court's permission to search the content of a person's electronic communications, prosecutors must then compel the email service provider to produce the relevant data. To avoid having the service provider turn around and tell its customer about the search, the government can also ask the court to grant a non-disclosure order, or NDO, colloquially referred to as a secrecy or gag order. Right now, there's no time limit to these orders. There's no standard to meet. All the government needs to do is cite one of 5 potential adverse results with no showing that it is necessary, and the court may grant the request. This bill requires the government to show and the courts to be convinced that the secrecy order is actually needed, rather than allowing both to treat this as a check-the-box activity. Gag orders would be granted for a much shorter period of time, with the opportunity for extensions only as necessary. And when the orders expire or are no longer necessary, the government would need to provide to the customer the warrant, details regarding the search, and a copy of any information disclosed. Prosecutors frequently seek secrecy orders in cases where there is clearly no need, and in situations where the government alone benefits. Unlike when a physical search occurs and a person has the right to go to the court to dispute the warrant, NDOs can keep the subject of the search in the dark until a court reverses the order. In the 21st century, federal prosecutors no longer need to show up to your office. They just need to raid your virtual office secretly. The NDO Fairness Act would do away with that rubber stamp by ensuring that courts apply a strict scrutiny standard to government requests with a written determination explaining their reasoning. By time-limiting non-disclosure orders, raising the standard of review, and ensuring that service providers have standing when they object, H.R. 7072 inserts transparency, reason, and balance into a system that for too long has been a free-for-all for the government prosecutors simply by virtue of it being too easy to overuse. If history and recent reporting has taught us anything, it's that we cannot trust the Department of Justice under any administration to police itself. It's imperative that the House of Representatives fulfill its role and ensure our laws are keeping pace with rapidly changing technology. I thank Chairman Nadler and Congressman Fitzgerald for their leadership on this bill, and our friends Senator Leahy and Senator Lee for their leadership in the Senate. I urge my colleagues to vote yes on this bill, and I reserve the balance of my time.
Gentleman reserves. The gentleman from Ohio is recognized.
Thank you, Madam Speaker. I yield myself such time as I may consume.
Gentleman is recognized.
Thank you. The NDO Fairness Act is a significant step in addressing the government's overreach and abuse of non-disclosure orders, also known as gag orders. All too often, the government attains a court order to secretly demand the communications of American citizens from third-party tech companies like Apple, Google, Microsoft, and Verizon. Through these orders, the government blocks these companies from alerting their customers or users that the government is looking through their emails and phone records. In other words, you don't get to know. The frequency with which the government uses these orders to demand information is shocking. One company received 2,400 to 3,500 orders every year between 2016 and 2021. That's 7 to 10 orders every day, every single day. Some of those orders do not contain an expiration. That means the government is authorized to spy on Americans' private information indefinitely. Think about that. You may never know that the government accessed and snooped on your most intimate information. More astoundingly, these non-disclosure orders are often approved by a rubber stamp process for routine investigations without any real showing of the need for secrecy. This bipartisan bill ensures that our rights enshrined in the Constitution are protected from government overreach. The bill requires courts to issue written decisions as to why orders are necessary. It sets a 60-day limit for such orders and allows providers to challenge unjustified orders in a court of law. Madam Speaker, I reserve the balance of our time.
Gentleman reserves. The gentleman from Rhode Island is recognized.
Madam Speaker, I have no further witnesses.
Gentleman reserves. Gentleman from Ohio is recognized.
Madam Speaker, I urge a yes vote. And yield.
That gentleman yields back. The gentleman is recognized from Rhode Island.
Madam Speaker, H.R. 7072 will insert due process protections into a system too often abused by federal prosecutors. Under the Stored Communications Act, the government often has no obligation to tell you that they've requested access to your email records, and it can prohibit your service provider from informing you of the search, even if your contract with the provider requires such notice. The NDO Fairness Act will require that the government show a need for a gag order. It installs common sense protections to ensure that any such orders are time limited and subject to scrutiny for renewal. I encourage my colleagues to vote yes and pass this important legislation today, and I yield back the balance of my time.
The gentleman yields back. The question is, will the House suspend the rules and pass the bill H.R. 7072 as amended? Those in favor say aye. Those opposed say no. In the opinion of the chair, 2/3 being in the affirmative, the rules are suspended and the bill is passed. And without objection, the motion to reconsider is laid on the table. For what purpose does the gentleman from Rhode Island seek recognition?
Madam Speaker, I move to suspend the rules and pass H.R. 3285, the 21st Century President Act.
The clerk will report the title of the bill.
Union Calendar Number 291, H.R. 3285, a bill to amend gendered terms in federal law relating to the President and the President's spouse.
Pursuant to the rule, the gentleman from Rhode Island, Mr. Cicilline.